Have you ever dreamed of finding a hidden chest of gold coins buried in your backyard? Or what about discovering an ancient shipwreck full of priceless treasure at the bottom of the ocean? It's a fantasy that has fueled countless movies, books, and legends for centuries. But here's the real question. If you did find buried or sunken treasure, would you actually get to keep it? Welcome back to Due Process Daily, where we break down complex legal topics so you know your rights and responsibilities in the real world. Today we're diving deep into the legalities of buried treasure, sunken treasure, pirate coins, gold bars, and everything in between. We'll look at who really owns treasure when it's found, what laws apply on land and sea, and famous real-life legal battles over lost riches. By the end of this video, you'll know exactly why the phrase finders keepers doesn't always hold up in court. Before we start, you should know that this video is not legal advice. The information provided is general and not tailored to your specific situation. It is for informational purposes only. If you need legal advice, get a consultation with an attorney licensed to practice law in your state. What is treasure under the law? First, let's talk about what treasure even means under the law. In Old English common law, treasure trove was defined as any hidden valuable item, usually gold or silver, found concealed with no obvious owner. Traditionally, if someone found such treasure, it technically belonged to the crown, but the finder often got a reward. In modern American law, the concept of treasure trove has mostly been absorbed into broader property law categories. Instead of simply calling it treasure, courts consider whether the item is lost property, mislaid property, abandoned property, or in rare cases, true treasure trove. Each category determines whether you can keep it or if someone else has a superior legal claim. Lost property is something accidentally dropped or lost by the owner, like a gold coin falling out of someone's pocket. Mislaid property is intentionally placed somewhere but then forgotten, like hiding a jewelry box in a barn and never coming back. Abandoned property is something an owner has voluntarily given up all rights to, like tossing an old couch to the curb. Treasure trove traditionally meant hidden gold or silver with no known owner. As you can see, finders keepers isn't a legal doctrine. The true ownership depends on these classifications and where the item is found. Buried treasure. On land. Who owns it? Now let's look at buried treasure found on land. Suppose you're out metal detecting and you find a jar full of gold coins buried under the surface. Who owns it? In most states, the answer is simple. If you find treasure on someone else's private property, the landowner usually has the superior claim. This is based on the concept that anything embedded in or attached to the land belongs to the landowner, not the finder. For example, if you rent a home and find a chest of coins buried in the backyard, the property owner, not you as a tenant, has the legal right to it. Courts generally hold that property owners own everything on, above, or beneath their land, unless it's specifically excluded. So, before you start digging holes in random fields or someone's ranch, understand that you could be trespassing, and anything you find may legally belong to them. What about public land or government land? This is where the laws are even stricter. If you find treasure on national parks, state parks, or federal land, you could face serious legal trouble for taking it. There are federal and state regulations prohibiting removal of artifacts or valuables from public land without permits. For example, digging up Civil War relics on federal land without permission can result in hefty fines, confiscation of the items, and potential criminal charges. In short, finding buried treasure on land doesn't automatically make you the owner. The legal title usually follows the ownership of the land itself. Sunken treasure, ocean laws, and maritime salvage. Now let's move from dirt to the deep sea. Sunken treasure, shipwrecks, and maritime salvage are governed by complex admiralty laws. There are two primary legal doctrines here: the law of salvage and the law of fines. Under the law of salvage, If you recover another party's property at sea, you are entitled to a salvage award. This doesn't give you ownership. It means the owner pays you a reward based on the value recovered and the risk you took retrieving it. For example, if you find a cargo container that fell off a ship, it's still owned by the shipping company, but you might get paid a percentage for recovering it. Under the law of fines, if the property has been truly abandoned and no owner claims it, you could be awarded ownership. But proving abandonment is difficult, especially with historically valuable shipwrecks. Internationally, there are treaties like the UNESCO Convention on the Protection of Underwater Cultural Heritage. This prohibits unauthorized excavation of shipwrecks over 100 years old in signatory waters. The aim is to protect historical sites from commercial exploitation. One famous example is Odyssey Marine Exploration. In 2007, Odyssey recovered over $500 million worth of gold and silver coins from a sunken Spanish galleon off the coast of Portugal. Spain sued, claiming ownership since it was a Spanish naval vessel. After years of litigation, U.S. courts sided with Spain, ordering Odyssey to return the entire treasure. The finders didn't keep it. The law decided otherwise. Native American and cultural heritage laws. Another critical area of treasure law involves Native American artifacts and cultural heritage protection laws. Under the Native American Graves Protection and Repatriation Act, known as NAGPRA, it is a federal crime to excavate or keep Native American human remains or cultural items found on federal or tribal land. Violations can result in substantial fines and prison time. Additionally, most states have their own cultural preservation laws protecting archaeological sites and artifacts. If you stumble across pottery, tools, burial items, or cultural relics, reporting them is legally required. Keeping or selling them without proper authorization is illegal and unethical. Remember, some treasures belong to a people's heritage, not to the person with the shovel. Metal detecting and treasure hunting laws. Let's talk about metal detecting, which is how many hobbyists find buried coins, relics, and old jewelry. Laws vary by state and locality. On public beaches, metal detecting is often allowed without a permit, but many parks, historical sites, and federal lands ban it completely or require strict permits. For example, using a metal detector on protected historical sites can lead to criminal trespass and confiscation of your equipment. If you're metal detecting on private land, always get written permission from the owner beforehand. Even then, you may need to clarify in writing whether you can keep what you find or if it belongs to them. These agreements protect both parties from disputes and potential legal claims later. Real-life treasure disputes. To bring this all to life, let's look at some real legal treasure battles. One recent example is the Fenn treasure. In 2010, art dealer Forrest Fenn hid a chest of gold, jewelry, and rare coins somewhere in the Rocky Mountains. For a decade, thousands of people searched for it, some even risking their lives. In 2020, a man finally found it. Legally, there were no disputes because Fenn owned the treasure and gave it away as a public challenge. However, lawsuits did arise from disappointed searchers claiming the hunt was rigged or they were misled, though courts dismissed those claims. Another famous example is Victorio Peak treasure in New Mexico. In the 1930s, a man named Doc Noss claimed to find a cave full of gold bars worth billions today. Over the decades, countless searches and legal battles erupted between his family, the U.S. Army, and the government over ownership rights. To this day, no definitive recovery has confirmed the treasure's existence or legal ownership. Finally, there's Oak Island in Nova Scotia, home to the world's most famous money pit. Treasure hunters have been digging for over 200 years, searching for rumored pirate treasure or lost Templar artifacts. Despite major excavations and TV reality shows, no definitive treasure has been recovered. The law there requires permits and royalties to the Canadian government, and any significant archaeological finds must be reported. How to protect yourself legally. So, if you want to go treasure hunting, how can you protect yourself legally? First, always research land ownership. Do not trespass or dig without written permission. Second, if you plan to recover sunken treasure, consult maritime salvage attorneys and seek proper approvals to avoid costly legal battles. Third, report culturally significant finds to authorities to avoid criminal penalties. Finally, consider entering agreements with landowners outlining your rights before you dig. In conclusion, while finding buried or sunken treasure sounds like the ultimate jackpot, the law often decides whether you keep it or lose it. The world is full of stories where treasure hunters spent their life savings chasing riches they could never legally claim. What do you think? Would you risk years of litigation or possible criminal charges for the chance to keep hidden treasure? Let us know your thoughts in the comments below. If you enjoyed this legal deep dive, throw us a follow one time and check out more breakdowns where we level up your legal IQ